You're watching Law and Crime's live coverage of confirmation hearings for Judge Brett Kavanaugh. He is President Trump's pick for a seat on the U.S. Supreme Court, and we are listening to testimony from peers, colleagues, law professors, and a number of high-level attorneys who have served a number of different administrations. Obviously, this is back and forth on the ideological lines. Linda Kenny Baden has graciously switched seats to join me across the table here. John Dean,
yes,
Richard Nixon's attorney.
Right.
Gets in the chair and says, I've got problems with this candidate's honesty.
Right.
How much weight does that carry?
Probably none. You know why?
Why?
Because this committee is going to vote across party lines, period. We're seeing that in the questioning. And that's what I think has to change about this whole process, okay? Because we know one of the main questions that was asked of the candidate yesterday, of Kavanaugh, to become a justice, was would he enforce the Nixon decision on whether a president could be subject to a trial court subpoena, but if it's a grand jury subpoena instead. And he said, I can't answer that because that hasn't come before the court. Now, I think that we're entitled as a public to know his views. And we're not. We're not going to get them. So we can assume what his views are, but we will not know his views. So whether he's lying or not, whether John Dean said he's lying or not, it happened so long ago, people aren't going to care. They're not going to remember. They want to know, what are you going to do for me now?
You know, his benefactors would say that's not necessarily a bad response, because it's one thing to have a view on a topic. It's another thing to completely disregard a case that comes before you and not listen to the arguments, not listen to the nuances and the subtleties about the specific argument at hand. And he's saying, I can do that, even if perhaps I have views on this.
Well, except that he did that with almost every question he was asked for. Do you think that the right to marry is settled law? He wouldn't answer that. Do you think Roe versus Wade is settled law? He wouldn't answer that. The only thing was settled law was a case decided 9-0 dealing with Brown versus Board of Education. So I think that's a little bit of a dishonesty. It may not be a dishonest person, but it's a dishonesty in terms of how he's feeling.
You know, the Brown v. Board is an interesting decision to continuously bring up, because it's one of those decisions where the court punted precedent and basically took an aspirationalist stand. It was not historical, it was not textualist, it was not originalist or any of these sort of musty old ways of interpreting the Constitution. It was very aspirational. So to hear him back up that decision certainly looks good in the court of public opinion, but it's certainly different from some of the views that we hear candidates like him espouse.
Oh, quickly, except that he keeps saying he's a textualist, he reads the Constitution, he reads the law, and that's how he decides opinion. So how does he really decide? The
interpretive method changes sometimes based on the subject matter. Look, we're going to take a quick break here on the Law and Crime Network. We will be back with more live coverage of the Brett Kavanaugh confirmation hearings from Washington, D.C. When we return, again, we will be right back in just a couple minutes.